hope everyone had a great weekend. We are going to start with requests for committee-sponsored bill drafts. This is our last opportunity to do that. Is today. Do we have any requests? Representative Humphreys.
Thank you, Madam Chair. I'd like to request a bill draft for RS 0692. It has to do with conscience protections for foster and adoptive parents.
Are there any questions, committee? Any objections? Okay, that is requested. Any other request? Last chance. Going once, going twice. Okay, gone. Okay. So today we are going to have a couple of presentations. I'm excited about them. Andrew Brown will be joining us remotely. He is tied up in another meeting, so we are going to have Rob Wyman come first. Rob, if you want to come to the speaker stand. He is the attorney consultant for judicial and national engagement for Casey Family Programs, and if I butchered that, you're welcome to correct me. Welcome to committee.
Oh, I see. Looking for the red light to come on. Okay.
Go ahead.
Okay, good afternoon.
Thank you.
Chair Howerton, Vice Chair Johnson, Ranking Member Owsley, and all the members of the Child Welfare and Foster Care Committee. I thank you for this opportunity to speak about opportunities for Kansas court system to improve its services to the state's children and families. As the chair just mentioned, my name is Rob Wyman. I'm an attorney consultant with Casey Family Programs. As my colleague Misha Martin spoke to, I think, last week, Casey Family Programs is the nation's largest operating foundation focused on safely reducing the number of children in care and building communities of hope. Our mission is to provide, improve, and eventually eliminate the need for foster care. We appreciate this opportunity that this committee is taking in looking into the role and the function of the court system as it relates to child protection, as this is a system that's guided by law. Slide 2, if you would. So a little just context about the pieces of things that I'd like to share with you in my opening comments. Discussing a little bit of context regarding decisions to separate children from their parents. A lot of my comments will kind of focus on the front end of the system. I'm happy to talk about kind of legal representation, the function of the courts throughout. I'll mention that a little bit, but a lot will focus on the kind of front end function of the courts. Exploration of fundamental constitutional rights of parents against government intrusion into the family. The court's role in applying the facts to the law, balancing parents' rights, overseeing the state's responsibility to protect vulnerable children, and discussing kind of that space, that tension that the courts sit in respecting family rights and also honoring the state's obligation to protect children. And lastly, I'll talk about some strategies to protect those rights, prevent unnecessary separation of children and their parents, and achieve all the goals of the child welfare system. Slide 3, if you would. It is important to understand that neglect is not the legal standard that permits a child to be removed from their parent or caregiver. The neglect definition may well describe what is going on in a home and allow for more investigation, oversight, supports of the family. But whether a child is separated from their parent is legally prescribed in protective custody statutes that cover more than just the presence of neglect. Separation of a child from a parent is legally supported only when there is reason to believe that a child is likely to or will sustain harm, and reasonable or active efforts have been made, when possible, to prevent the need of removal of the child. In Kansas, somewhat unusually, harm is defined. Harm is defined as physical or psychological injury or damage. The committee may recall testimony from officials a couple weeks ago, DCF officials a couple weeks ago, where they pointed out the circumstances described as neglect are the primary named reason of children coming into care. We at Casey, looking across the country, that's not at all unusual. Across the country, you'll find states reporting 60 to 85% of cases that come into care are labeled as neglect cases. The critical question is how to avoid unnecessary removals of children from their family as we respond to safety issues. We know that there are many scenarios where children experience conditions that would constitute neglect when applied to the letter of the law, the neglect statute. But the more serious question, if removal, involuntary separation of children from parents, is also necessary. While neglect is not the legal standard for removal, it plays an important role. Something that is critical to child protection practice related to courts is the different thresholds that the neglect statutes and the protective custody statutes represent. Here we're talking about the difference between jurisdiction and custody. Jurisdiction is the authority the court has to make orders that the parties must follow and that the court can enforce. Jurisdiction is, this is the neglect statute. You might think of the neglect statute, that definition of a child in need of care, as the front door of the court. That gets a case into court and allows the court to exercise jurisdiction. But there is a whole separate threshold that is custody, the state having custody of children. This is the protective custody statute. So when we talk about a child coming into care due to neglect, we should understand that it may be the definition of neglect that allowed a case into the court, but it is specific allegations of imminent harm that allow a child to be separated from their parents. Around the country, as under the laws of Kansas, law enforcement has authority to separate children from their parents in emergency situations without a court order when they reasonably believe a child will be harmed if not immediately removed. That language is straight out of the protective custody statutes. One of the aspects of Kansas system that the Child Welfare Reimagined effort examined was how in recent years over 40% of children are coming into care by law enforcement removals. It is critical that legal due process is designed to ensure these removals are indeed necessary in terms of imminent harm, that reasonable efforts to prevent unnecessary removal were offered when available, and parents' rights against state intervention are protected. Social workers and law enforcement have very different education, training, experience, resources, and missions. Where a social worker is trained and equipped to assess parenting and child safety, engage parents and children with interviewing techniques designed to increase connection and teaming, and offer a wide variety of services to support families when possible, where law enforcement are equipped with the tools and training that enable them to handle some of society's most dangerous situations. It is not unreasonable to assume that law enforcement officers are more likely to deem a situation an emergency based on the resources and tools available to them. Police simply do not have the expertise nor the role of mitigating safety issues by applying supportive and collaborative social work that a social service agency does. For example, social workers are trained and safety assessment tools include methods to assess the protective capacity of parents and identify available supportive factors to supplement those capacities, such as family networks to support safety, connections to food networks, housing resources, domestic violence shelters, and in-home parenting support programs. Many of these resources were described to the committee by DCF officials in the presentation on Family First Preservation Services Plan. It is important to note here that the law requires the state to make reasonable efforts to avoid separation and to keep the family safely together. This is the national standard. If after all of those reasonable efforts the child cannot be kept safe with the family, DCF must seek an order for removal from the court. That is not to say law enforcement is not a necessary part of the system to support children at any time of the day or week. But in many circumstances where families are in crisis, even where substance abuse is involved, the situation is not one that requires criminal justice response, but instead a social work response to assist families to create a plan to keep children safe at home or with family and kin. Law enforcement is always going to lead and be involved when a child is a victim of a crime. And in many of those types of cases, social workers may also have a role, though not always. But investigating criminal offenses and evaluating a family for safe parenting and employing strategies to achieve safety without a separation of a child from their parent are two different professional roles. Can you move the slide? Thank you. Child protection response is a civil legal system designed to keep children safe while the state makes efforts to serve families so they can keep their own children safe within their families. Where a police officer has reasonable belief that a child in home is in need of immediate aid, that officer is allowed to enter the home without the consent of the parents to determine if the child actually needs immediate aid, and if so, to arrange for it or offer it. This principle, based in the Fourth Amendment of the U.S. Constitution and Section 15 of the Kansas Constitution Bill of Rights regarding warrantless search and seizure, also applies in the child welfare arena and is reflected in the Kansas statutes governing who can remove a child without a court order. Police officers who reasonably believe a child will be harmed if not immediately removed, according to the law, shall take the child into custody. In other circumstances, a police officer or a social worker, or frankly anyone, is required to go to court to seek an order for protective custody and present information that that child will likely sustain harm if they remain in the care of their parents, and also describing efforts that were made to maintain the family unit and prevent unnecessary removal. Neglect is a range of behaviors and circumstances that is contextual to every situation, each child, and each factual scenario. And we have found through research nationally that there are many strategies and tools that can be used to address these serious situations, addressing the safety needs of children while maintaining children with their parents. So let me now shift to the role of judicial oversight of this process. Parents in the U.S. have a fundamental, constitutionally protected right to the care, custody, and control of their children. These rights must be considered when government seeks to intervene into the familial relationship, when the concern is that vulnerable children are at risk of serious harm from unsafe parenting. Government infringement on parental rights is subject to this test, whether intervention is necessary to achieve the goal of safety. So the role of the court, and specifically a judge, in a child protection proceeding is to evaluate the evidence presented and consider whether or not it complies with the legal standards for involuntary separation of a child from their parent, and, when required, whether reasonable or active efforts were made to maintain or reunify the family. This judicial review is a necessary form of due process, which cannot be overlooked even when we're fearful of a child's risk of harm. Not all circumstances rise to a level that require the government to take involuntary action entering the home or removing a child. Many situations can be made safe with less intrusive actions. Stories of neglect often involve circumstances where connecting families with support or services can resolve the immediate safety problem and allow the family and officials to improve the underlying conditions in the home. Again, in part, what I'm talking about is the difference between jurisdiction and custody. Could you please move the slide? Parents in Kansas and across the country have generally been afforded the right to counsel in protection courts. And we're finding more and more about how legal representation can be effective not only in protecting fundamental rights, but also to increase parents' engagement with courts and the agency, increase attendance and compliance with court orders, improve outcomes for the family, the court, and the state, all without compromising child safety. I think we all can imagine the shame and adversity involved in government intervention into a family's parenting, and how hard it would be to lean in and engage that process, even where a family is fully aware of the need for assistance to address personal, financial, or other struggles. We hear consistently from families that going to court is lonely, that they don't understand the words and process, don't think that the professionals hear or understand them, and it often deepens trauma they already have experienced in their lives. High-quality representation can provide connection to in a confidential and loyal relationship, giving information and advice about the process, advocacy for their true needs, and support for them, whatever their experience and journey is through the court process. That is why you see the outcomes shown on this slide. And I won't read through them one by one, but I want to touch on a few. These are outcomes that we've seen through studies of parent representation projects, parent and child representation efforts, when generally the level of parent representation is raised, usually through managing caseloads, offering appropriate pay for the work, and then employing standards of practice with that, and then looking at how that affects a system. And what we consistently see, kind of the top line outcome that I would look at, is more reunification of families and faster reunification of families and faster other permanence for children. In the end, fewer days in care for children. This talks about no adverse income on child safety. Generally, that's measured. How do you measure child safety out in the community? We generally measure that by our children re-referred to Child Protective Services. Is there an investigation, a substantiation? Are those kids brought back into court, brought back into care? And generally, in all of these studies, the improvements on reunification, permanency for children, time and care all come without increases in re-referrals, refilings, kids coming back into care. The way a number of these studies look at accomplishing those goals, like I kind of described above, increasing parental engagement and perceptions of fairness. Parents generally understand the process. They understand the words, the acronyms. I can tell you that my colleague and I just spent the morning sitting in court, and not unusual in Kansas as anywhere else. It's full of acronyms and words that I know. My colleague is not a lawyer. Maybe she didn't even know, let alone the parents and children who are sitting there subject to the court's statements and orders. And just the feeling that puts in a parent or a child or anybody, like, this is a process that's going on that's going to determine my life, and I don't even understand what's being said. But high-quality legal representation offers, generally, I'm going to be told beforehand what's going to happen, and these words mean this thing. This is what we're going to present to the court. More individualized case plans and better access to services, right? So the idea is we're going to take, as a family, a more active involvement in creating a case plan for my family, rather than just hearing what's available. Visitation, what a lot of folks around the country now are calling parenting time or family time, is one of those things that is the most closely associated with reunification of families. Family time, parenting time, the reason that word is shifted, you can imagine a parent being offered visitation with their child who's in state custody. And we're having to understand that we have to presume that if due process has been in place, and a family is in the court's jurisdiction and the child is in the state's custody, that there's a problem in the relationship between the parent and child. And when we think about visitation, and I would encourage you to ask your local jurisdiction, when a child is taken into custody, what's the usual visitation plan? What's the usual contact between parents and children? I've heard it around the country, as much as twice a week for 2 hours, to numbers that are measured on a monthly basis. Once or twice a month. Doesn't start for 6 weeks. Waiting for parents to engage in other processes, which generally are not good for children, is what we find. It's extended time away from children. And these are all kind of based on the idea of we're going to maintain the existence of some relationship between parents and children. What high quality legal representation often can lead to is more frequent and better visitation, parenting time, family time, where that relationship is receiving supports, has the opportunity to grow and maybe improve along with all the other improvements and the changes that are being sought in the case. Better decision-making off the top. Any court, I think it's, the next slide, don't need you to go to the next slide, but on the next slide, there's going to be a phrase. The judge's decision is only as good as the case that's brought to him. And high-quality legal representation means that the court is going to hear a more balanced presentation, more information, and judges are going to be able to make better decisions. And then this is the one, I'll be honest with you, I'm not excited about talking about fiscal savings from improvements to human experiences in court, but I'm also enough of a practical person that I understand that's real. When we talk about high-quality legal representation and talk about confining caseloads, paying reasonable salaries and such, that's money. And that's money that this body or a county body or somebody has to be thinking about. And what we find consistently is that improving parent representation saves money. There's been some studies where that's been costed out. One very extensive study that occurred in New York City where they looked over 11,000 families, 18,000 children over 4 years, and found the number of days per case on average that children's time in care was reduced by about 400 days in care per case. And they were able to cost that out and found that the city stood to save about $48 million over the time of the study had the entire system been under this high-quality legal representation thing. So we have some studies that actually have costed out the benefits of legal representation. And I mention that in large part because what this often involves is upfront investment. And what anybody being asked to engage in upfront investment is, how's this going to come back? How, does this investment pay off? And amongst all of the human costs, it also pays off as a fiscal matter. The committee heard testimony from DCF a couple weeks ago outlining real success with services under the state's Family First Plan. The committee also discussed reticence families sometimes feel about reaching out for support before circumstances get to where safety of children is compromised. Preventive legal advocacy programs, almost always offered in a multidisciplinary format of a lawyer, a social worker, and a peer parent, working as a team, have regularly shown that they can increase the family's engagement with the process and avoid significant numbers of removals that likely would have happened otherwise. They do this by delivering legal advocacy through a team approach. A peer parent, and by peer parent, just to be clear, is a parent who's been through the, in Kansas, child in need of care system and has come back to be an advocate and to be a mentor and to work with parents who are presently going through that process. A peer parent is able to connect with a family in a way that other professionals cannot, reducing a parent's apprehension and opening opportunities to engage. Peer parents and social workers are then able to learn truly what a family is struggling with and what might help. And then the attorney is able to offer legal information and advice about their situation, advocacy in various ancillary areas, meaning not the actual case, but housing, access to benefits, family law and guardianship processes, etc., as well as work with the agency to ensure the family is being served and children are not unnecessarily removed from the home. Programs across the country are reporting significant success preventing removals in situations that otherwise would have gone down a traditional, traumatic, and costly court process. Next slide, please. So there's my judge's decision is only as good as the case it's brought. I offer in this slide and the next a couple just resources for your kind of beginning education and looking into some of the things that I'm speaking about if you so choose. I talked about parent representation being delivered in a multidisciplinary format. The very traditional, the very kind of basic version of that is a lawyer, a social worker, and a peer parent working as the legal team for the parent. When I say social worker, I don't refer to the agency's social worker. I refer to a social worker that's working in the law office with the parent and the lawyer to support families. It is really the leading edge of parent representation around the country is growing and is pretty significantly, we're seeing it in a lot of places around the country. So I have a Casey resource to read about multidisciplinary parent representation, which then in and of itself will have other links if you're interested. And the American Bar Association has a PDF of some description of multidisciplinary parent rep. Preventive legal advocacy, this is really the new kind of leading edge of child protection practice in general from a legal advocacy point of view. It is spreading across the country. There's a Casey brief about that you see linked up there. There's also, Casey was supportive of creating a kind of gathering center of resources and folks doing preventive legal advocacy at the Barton Center, which is at Emory Law School in Atlanta. And that website has a tremendous amount of resources just about preventive legal advocacy. The National Association of Counsel for Children is a great resource there for children's legal representation. I had the privilege years ago of being part of a study of a model of children's representation called the QIC Child Rep Best Practice Model. It's a mouthful. But it basically was creating standards of practice for attorneys representing children, whether in a best interest or stated interest model. And involved training and such like that, and then we examined the effect of being trained in that model and not. And again, we saw more reunification, more involvement of children in their legal case, more involvement between the professional parties discussing case plans, needs for children, better decisions by judges. Lastly, I wanted to mention another thing that is gaining acceptance, gaining implementation around the country is the idea of statewide offices of parent representation or child representation. There are a number of states that have done that in the past. There are a couple that are sort of ramping that up as we speak. Montana started up a program, and I've had the privilege to do some training and work with them. Their program's probably a year or two old and is getting going. It was established within their statewide public defender system. Probably what I'm going to guess is maybe a closest colleague of Kansas is Oklahoma. They are in the process right now of ramping up their statewide parent and child representation office. I had a chance to speak with the person doing that, Gwendolyn Clegg. And something that stuck out to me as very analogous with Kansas. Oklahoma, I was mentioning to them what I had read about what we think about legal deserts in Kansas. And I've quoted an article I read, I think it was a year or so ago when I was coming to speak to the Joint Oversight Committee. And it said that 80% of the lawyers in Kansas live in 6 counties out of 105. And obviously, if you're in one of those 6 counties, but if you're not there, and especially in a state with a county-based, I think judge-based contracting process with attorneys, it can become just this battle of, well, I'm going to grab that attorney and then you're not. And then, of course, you have attorneys with 2 or 3 jurisdictions when I'm in front of you, but I have a case in your court, and they get kind of strung out like that. And she's finding, so one thing the leader of a statewide office has to do is go around all the counties and say, now we're going to support parent representation and or child representation centrally in the state and not under your control, which is a conversation to have. But what they found is that they're able to kind of work on an economy of scale a little bit. So not only are you providing more pay structure, more training structure, more supervision and oversight structure, institutional memory, camaraderie amongst your parent and child representation colleagues, but you also have the ability to kind of work representation around the state rather than it be kind of hungry hippo grabbing whatever attorneys are available. So I just want to mention that as one opportunity, and of course at Casey we are happy to connect folks or bring folks here to talk about how that works. Just in closing of my opening comments, closing this part out, we observe how government agencies and courts engage with families who might be struggling, and it leads us to understand new strategies in the effort to support families and communities to be healthy and keep children safe. As we track and observe national data, we share that information with the child protection systems to work to achieve better outcomes for children or families. One data point from Kansas we want to be sure to keep in mind is that about half of all children who come into care who have been separated from their parents will ultimately never be reintegrated with their families. About half. Which I can just kind of put into context when you're in court and the judge after that first hearing, where oftentimes children have been brought into care. If a judge is being true, almost every judge is going to say, look around the room, this is your team, we're here for reunification, we're here to support you. And that's absolutely true. I don't mean to counter that at all. But if the judge is also being true, it's a flip of the coin whether your children will ever live in your home again. For a child to never return to their parents is the most significant level of intervention our legal system takes with regard to child protection. Of course, we all know that sometimes that result is necessary. But we also understand that entering the child protection system can have devastating effects on a family already on the margins, and sometimes families who might have a reasonable pathway to resolve their issues lose hope, can't connect with professionals, and eventually lose their children permanently. For so many reasons, then, we want to be sure we're not unnecessarily separating children from their parents, given the significant human and financial costs. So that is the conclusion of my prepared comments. Of course, here to take questions if anybody has them.
Thank you very much. We're going to listen to Andrew online real quick, and then we'll take questions. Okay. So committee, write down your questions so you don't forget them. And then if we are ready, I'd like to welcome Andrew Brown to committee. He's joining us. He is from the Texas Public Policy Foundation. Andrew, are you there? Are you muted? Can you unmute?
Yes, ma'am.
There you are.
Madam Chair,
Great.
I'm here. Can y'all hear me now?
Yes, sir.
All right. Well, Chair Harrington, thank you. Members of the committee, it's a pleasure to be with you today. I appreciate the ability to join remotely. In Texas, we are likewise in a legislative session, so I am running between multiple meetings, but I wanted to make sure that I carved out the time to be with you all today to give you some background and perspective on the bill providing a notification of rights for parents who find themselves involved with Child Protective Services. I have provided a copy of a research paper that the Texas Public Policy Foundation published a few years ago now tells you how long we've been thinking about this topic and working on it. Um, Essentially providing a background and foundation for an understanding of how to develop um, a notification of rights proposal for families, as well as the constitutional and legal foundations of such an endeavor. Those constitutional and legal underpinnings come from the basic fact that the relationship between a parent and child is one of constitutional dimensions. It has been called perhaps the oldest fundamental right that has been recognized by the Supreme Court. That is paraphrasing there from Justice Sandra Day O'Connor's plurality opinion in the case Troxel v. Granville. We provide notification of rights for individuals who are involved with our criminal justice system, understandably so, because of the awesome power of the state in the criminal justice system to infringe upon and limit the liberty of individuals. The child welfare system is somewhat different in the fact that it is predominantly a civil law matter, that you can have crossover, obviously, into the criminal justice realm. However, the decision to separate a child from their family will go through the civil courts, which has a completely different set of protections around it as compared to the criminal justice world. However, the impact of these decisions is arguably equal, if not greater than, those of you who are parents like me. If somebody had given you the choice of go to jail for a little while or have your kids taken from you, going to jail for a little while sounds a whole lot better than having your kids taken from you. So with that perspective in mind, because of the severe nature of removing a child from their family, potentially terminating that relationship legally for all time, and specifically the trauma that both children who are removed from their families as well as the families themselves endure as a result of involvement with Child Protective Services. These are factors that emphasize the critical importance of informing families of what their rights are when they find themselves in these situations. As Rob previously had discussed with the representation piece and the shift in where child welfare is going in practice toward promoting family integrity and minimizing the number of kids who are coming into the system, informing families of their rights and connections with these procedures and processes, which are fundamentally a police action as they are practiced, in my opinion, is phenomenally critical. So a good example, when you look at the bill that we passed in Texas, the draft language that Chair Howerton is proposing there in Kansas, notifying families of the fact that they have the right to consult with legal counsel is critical because that knowledge is combined with information about here are resources where you can go and obtain legal counsel should you seek to exercise that right, improves the outcomes in those cases. Families who are engaged with legal counsel and children whose parents have legal counsel tend to find better outcomes as a result of throughout their involvement with the child welfare system. So, that is kind of one basic example to bridge the two testimonies that you all have heard today, how a notification of rights can actually enhance the uptake of representation programs that have been proven to work and produce better outcomes across the country. Another key thing about the legislation that we passed in Texas that I can see reflected in Chair Howerton's bill is the sense that there are no new rights being created. As we were working on the research and building the case for passing a parental notification of rights in connection with CPS cases, We spent time digging into existing code. We call it the Department of Family and Protective Services in Texas. It's our CPS agency, looking at their policy and procedures handbook, the rules that they have produced that govern investigations, as well as court precedent to get a holistic and deep sense of what are the rights that are already recognized and protected that families have in connection with these cases. And we structured our bill around those rights that already existed, that these families are already recognized as protecting, and as protected for these families, and in many cases, that the department itself, in its practice and procedures manuals and in its rules, recognized that these families possessed these rights prior to the bill even being passed, or even being proposed for that matter. And so it's really critical for us to emphasize that these are not new rights being created. This is simply information being provided to families about rights that they already had. The ability to exercise a right, no matter what that right is contingent upon the knowledge that one has that right. And I would say that the knowledge that one possesses a right and may exercise that right is critical to the functioning of a representative democracy that values principles of liberty and personal responsibility. It's critical to the advancement of justice that the people understand what rights they have, the limits of those rights, and how they can go about exercising those rights. And then in that sense, the Notification of Rights bill is a bill that I'm incredibly proud to have been involved with in Texas, because it is advancing those rights and making it easier for families to understand not only what the process of an investigation is going to be like, but having some confidence that there is a fair process in place that they'll be able to navigate with knowledge and assistance that comes from being aware of those rights. I emphasize that point because there is a lot of fear involved with CPS coming and knocking at your door. Prior to going into public policy, I was actually in direct service and helped start a nonprofit organization that served families that were on that edge. They were, at very high risk of having their children removed by Child Protective Services. And our entire goal was to help come around these families with community supports and to help them address those issues that were putting them at risk so that that child would never enter Child Protective Services. We were highly successful at doing that. But as we were testing our model, we had families come through and do exit interviews so we could learn about what was working, what wasn't working, what they liked about us, what they wish we had done differently. And one of the first success stories that we had is a young mom who was able to maintain custody of her children and get an apartment, get a job, essentially find stability through the services that we were offering through our program. And during her interview, I don't know what came over me, where this question came from. Perhaps it was God placing a question into my brain that I hadn't thought of before, but I just asked her, why did you come to us when the agency has all of these other programs and all of these other resources that you could have called them and gotten some of these same services or similar services? And I will never forget the moment I asked the question, because she looked at me like I was an insane person. And she says, why would I call those people for help? Those are the people who want to take my kids from me. And that was the light bulb moment for me and for our entire organization, that the power of the model wasn't necessarily the services and the programs we were offering. You could get those programs, similar programs, anywhere else in town. The service that we were offering removed the fear of asking for help. It gave the people we were serving confidence that they had protection from the thing that they feared most, which was losing their kids. Now, you can't avoid involvement with CPS in all circumstances. There's a place for it. Sometimes it has to happen. We hope to reduce those instances through strengthening communities and strengthening families on the upstream side. And that's always going to be a scary thing when CPS comes to knock at the door. But you can make it less scary by letting families know, even though we're here, and even though you're going through and you'll be navigating a process that is by its very nature is scary because of what it can result in. You have protections in the law. The law applies to CPS just as it applies to everyone else in society. And these are the laws that give you protection and that limit us. And here's how we can, and they set the roadmap. These are the rules of the road and show us all how we play fairly and can work well together throughout this process. And to me, I think that's one of the most important aspects of a bill like this is providing information, providing education, especially around the fact that the law provides protections for families when they're going through one of the worst things a family can experience, gives families confidence as they work through the system and helps them as they try to navigate this system, reduces the sense of I'm flying blind and the entire deck is stacked against me. The awesome power of the government is coming after me. There's nothing I can do. There's no protection I have. What this bill does is it says, no, there are protections. There's a path through this wilderness. There's a path out of this darkness. And the people and the legislature and the government of the state of Kansas can provide that to you and are willing to provide that to you so that you can come in clear-eyed and hopefully be successful at maintaining your children and keeping your family together. I appreciate the opportunity to speak with you all. I'm happy to answer questions about our experience in the state of Texas, as well as any questions about the policy itself. Thank you for this opportunity.
Thank you, Andrew. And just to clarify, I did introduce this bill, but this came as a request from the Joint Oversight Committee as well. So it's kind of a group effort on this bill. I just have one question for you. I know it's been pretty quick. Do you have any outcomes or anything you could discuss about the bill and how it's working in Texas?
Yeah, everything that I'm hearing about the bill, unfortunately, we don't have data reports on its utilization. Everything I'm hearing is that the department has implemented it and that it is working as intended. Families are exercising rights. They're curious and seeking out legal counsel and legal protections. With anything, this bill went into effect in September of 2023. So we're, a little over a year into implementation. The department very quickly updated its policies and procedures and got the notification of rights out into circulation amongst the investigators and the caseworkers. They were a little bit, I don't want to say ahead of the game, but it wasn't as hard of an implementation process as other things can be, partially because, like I said, they already had many of these rights in their policies and procedures, and the caseworkers knew that these existed. They'd been trained on them, and even would have a little handbook, a little printed handbook that would be part of the big packet of information that they would hand a family at the door when an investigation started. So this implementation was made easier because of that, and all it really required them to do was update a few policies and procedures and then implement the verbal notification of rights. It wasn't just here's a pamphlet that is going to get lost in a stack of papers. It was I'm going to walk you through this and explain this to you face to face while we're here at your front door. And that, I think, has been one of the most key elements of the legislation and the policy at ensuring that it actually works, and that families receive the information and are able to exercise the rights that they're provided for.
Okay, committee, any other questions for Mr. Brown? While we have him, I want to be respectful of his time. Okay, Representative Page,
Mr. Brown.
do you have your mic on?
Yeah, it's on. I'm sorry.
Perfect.
I hear what you're saying, but I'm having a little problem with how do you pay for this? I know you're saying, now, is Brown this guy? I think I got him mixed up. Oh, okay. I still kind of find it's right. They should know their rights. We should do everything. But my issue with both presenters is you got one in society. What I'm hearing, everybody wants to cut, and we don't want all this fat. So where is all this money coming from? And then who's going to pay for the program? Who's going to pay for the attorneys? And we don't have enough attorneys now. So it just sounds good, but it just seems far-fetched, because how do you pay for it? That's the issue. In regular court, if I don't have the money to pay for a good lawyer, in my world, the poor and the ignorant go to jail. They don't know and they don't have the money to pay for it. If you have money, you can do a lot of things. So who's paying for all of this? Since I've been here, my little short tenure, money's a big issue and everybody's trying to cut the fat. And where is this money coming from? And who's paying for this?
So Representative Page, we're not proposing that we would provide representation. This is just something that we would notify parents of their rights, that they can get representation. So there's not a fiscal note on that. Yeah.
No, he was saying the attorney.
Yes. Yes.
Again, thank you for that information, but it still boils down to.
He's given us a national.
We have the people, the manpower to do this.
He's given us a national perspective.
Okay.
Yeah.
But
no, that's fine.
Money's an issue, and that's what concerns me. How do we get that, even just to provide the information, to have the manpower? We don't have enough people in all these departments now, and you still hear, we got to cut, we got to cut, you got to get it down. So how do we do this? And that's my concern. How do we do it with the limited resources we have now? And if we cut more.
We'll talk more about that when we get into the bill. This is more of a presentation. Are there any other questions for Mr. Brown? Okay, thank you so much, Andrew. I appreciate your time and your perspective on this. I know you are super busy, so we will let you go.
Thank you, Madam Chair. Thank you, members of the committee.
Okay, thank you. Okay, questions for Rob Ryman. Do we have questions for him? Representative Humphreys? Rob, would you mind coming back to the speaker podium? I don't know what to call that.
Podium, yeah. A little bit the same question the previous representative had, but you talked a lot about high-quality legal representation, and then you seem to, a little bit of a solution might be a central control. And so what states have that central control? And are you talking about central control for guardian ad litem or for parent attorneys or both? And who's done what? And just give us a little history on that.
Okay. Are we on? Are you able to bring up my slide? I can go to the last one. I forgot a slide that'll get to this and the representative's question a little bit. So the more recent ones are Oklahoma and Montana that I mentioned. A little bit more going back a little bit further. Colorado, New Mexico is opening up right now. My home state of Washington, it was kind of the first. It's been about 25 years in place. I could look and ask about more statewide programs. There's more than that.
And is that a statewide central control for guardian ad litem or for who? For what?
Parent and children's attorneys. Some states have stated interest attorneys for parents, but for children, sometimes they're stated interest attorneys, sometimes they're guardian ad litem or a best interest attorney, sometimes they have both models.
And so you're May I?
Sorry.
So you're aware of the bill we've had kind of floating around the last few years in Kansas for representation for children. And I think that isn't going to go anywhere at this point. I mean, it seems like it has kind of fizzled a little bit. But is that what you're talking about too, representation for, are you familiar with what our bill was? It wasn't just a guardian ad litem, it was an attorney for the children, not just for the best interest of the children.
Right.
And so I don't know if you had a thought
Statewide
about that bill.
offices have employed both models.
Okay.
Some states we're doing this model. Some states are, in our state, we have both models available. There might be younger children have guardian ad litem, older children have stated interest, and the statewide office is managing both of those.
Mm-hmm. And are you suggesting that they've used 4E funding for that?
Yes. So this is something.
All of these states that you mentioned, or? And it does seem like in Kansas, we've sort of, we haven't embraced that fully yet.
I noticed the deputy director is here, and she could speak to a little bit. So if I could, kind of in responding to both questions, I forgot my last slide, I apologize. So in 2018, the federal government started saying that states could draw down 4E reimbursement, is what it's called, for parent and child representation. For years, states have been drawing down reimbursement money under 4E for the state's council, but not for parent and children representation. That change was made in 2018. Last year it was codified, so it was made more specific. It is also in place for, like I was talking about, multidisciplinary representation. So whether in a child law office or a parent rep office, if you have social workers, peer parents, psychologists, investigators, other things that come with the law office, those costs can also be part of the 4E reimbursement. Similar to your 4E, it's the same program where 4E is reimbursed for foster care costs and such like that. It's that same representation. The link at the bottom there is to about a 4-page report, kind of the current state around the country of states drawing down 4E representation. You'll notice that about 3/4 or more of the states are drawing down 4E representation for parent or child representation, many for both. The representation, or the provision also allows for drawing down representation for the representation of children or their parents who are candidates for foster care. And this is, I think you heard the deputy director in her testimony, I think it was last week, talk about the Family First Preservation Act plan, and those, I think in conversation with you, Representative Humphreys, about how they get to families and can they go more upstream. And there was this discussion, well, that money applies to candidacies. This is the same thing. It applies to candidates. So it does go a little bit into the prior to a court case being filed.
All right, thank you. I appreciate it. Thank you, Madam Chair.
Deputy Secretary Keys, would you like to address or say anything? You're welcome to, or I know you're not prepared. Thank you. Thank you for being here. We'll come back to you, Rob.
Hi, thank you. Tanya Keys, in the role of Deputy Secretary with the Department for Children and Families. With regard to the high-quality parent legal representation, we're not, there is a link to a report that was published, it appears fall of 2024, so just a few months ago. Kansas is not on that map, but we have started it. We started it in the fall of 2024, so we are taking advantage of federal funding opportunities for legal representation. We developed training materials. We worked with Office of Judicial Administration to do a webinar, or sort of it was a call we had with counties and also with county government as well as county courts. And we have a memorandum of agreement that if a court is interested in the state and DCF helping to facilitate claiming or being able to take advantage of those federal funds, we enter into an agreement for them for their costs, and they have a reporting structure. So we are taking advantage of that. Kansas does also have pre-petition legal services that we cover. We have that through Kansas Legal Services, through some of our state dollars, And that's in 9 counties for pre-petition high-quality legal services.
Thank you for clarifying that, because what I remembered when we had quite a bit of discussion about the 4E funding was that the judicial districts themselves had to sort of initiate that. And, you know, what I hear you saying is if they want to do that, then DCF will assist in how to do it. I mean, we have 31, I think, judicial districts in the state of Kansas. And what we were hearing was some of those smaller judicial districts are just like, there's too many regulations, we don't know how to do it. But if you have initiated helping them, or you can do it, DCF can draw down some of those funds themselves, that sounds great. And thank you for getting going on that, because it does seem like if the money is available, we should be, you know, taking advantage of it. So, yeah, thank you.
Yes, thank you. We are offering technical assistance. Again, we did training. We are doing, to clarify, memorandum of agreements with county government, not the judicial district. We actually do the agreement with a county so that we can help them with those funds. So just a little bit of a technical difference between a judicial district and a county government.
That was one of the things that I learned a couple years ago, that funding actually comes through the county for their representation. So that was very interesting. Did that answer your question, Representative Page?
No, I just wanted to ask the follow-up question to what she just said.
Can you get on your mic? And
Yeah.
Yeah, perfect.
Is there,
Thank you.
excuse me, Madam Chair, is there any fear that these funds will be cut?
The 4E funding's federal.
Okay, but considering who's in office at this time, is there any fear? And I don't mean, I'm just trying to figure the whole thing out.
Yeah.
Is it any fear that the funds could be cut?
I don't know. We'll have to wait and see, I guess. Okay, I think Representative Roser has a question.
Thank you, Madam Chair. I have a couple. Okay. My first one for you. I just, super simple questions, yes or no. For slide 5, you were going over some of the advocacy issues. Do you want him to pull it up?
That'd be great.
To slide 5, please. Part of what you said anecdotally was unprepared and confused families, the lack of legal advocacy, lack of high quality representation, improving parent representation. Can you agree that in the state of Kansas there is a lack of those resources across the state for child welfare?
I'd be stepping out a little bit beyond what I know to give a yes or no answer to that. But what I understand is that caseloads and salaries and such for parent representation is a struggle here. Yes.
And then for visitation and reunification efforts, you touched a lot on that and talked a lot about that. The consistency of those visitations and reunification efforts they vary case by case, correct?
Should.
Okay, and so when it comes to predisposition reports and the timeliness of the child welfare agency to give those, would you also agree that those also would vary from?
Reports? Mm-hmm. I wouldn't know. In Kansas, okay. Yeah. It wouldn't be unusual, but I couldn't say. I don't know about that in Kansas.
Okay, and so all that to be said, are there any limits on the number of continuances that you can apply for the courts when it comes to disposition hearings or permanent custody hearings?
There are some things that have to happen within certain timelines, and so those may be a barrier for that, but generally no. If parties come to and make a request to continue a hearing, move it out for a reason, the judge assesses that reason and can say yes or no. Okay, so if there are inconsistent visitation and reunification efforts for a family, could we gather that it might be difficult to push a permanency hearing sooner rather than later if those visitations and reunification efforts aren't happening? Certainly the subject of disposition reports, ongoing reports, efforts for the family to reunify providing visitation for the family should be subjects that should be brought to the court in every single hearing, permanency hearings or review hearings or whatever.
Thank you.
You're welcome.
My next questions are for Deputy Secretary, if you're willing.
We're going to hold off on that because she's not really a presenter here. So you can get with her afterwards.
Okay.
Okay? So any other questions for Rob? I have Representative Carr.
Thank you, Madam Chair, and thank you, Rob, for your presentation. And this is just a question regarding the KC Family Services. Do you still offer the Knowing Who You Are series?
Knowing who you are. I'd have to check in and see. I'm not familiar with that myself.
Okay. I'll get with you offline. It's not a part of what we do here that I know of, but I wasn't certain if you still offer that, and if you're unaware of it, then there's a possibility that you may not, but I can connect offline with you with respect to that.
Sure.
Thank you.
KC Family Programs has kind of two big halves. One is the systems improvement consulting side. One is family services side, direct practice. That's sounding to me like something we might do over there. And so that's why I might not be so familiar with it. And I will check into that.
All right. Thank you very much. Thank you, Madam Chair.
Any other questions? Representative Owsley?
Thank you, Madam Chair. Thank you, Rob. So the statewide high-quality legal representation, how did those come to be? I mean, it seems like such a daunting task. We have our public defenders here in the state of Kansas. We have our attorney shortfall here in the state of Kansas. We have made some attempts to add pay parity to our public defenders. I don't think it's been enough, but it's been what the committee has decided we can invest at this time. So while I agree with the concept, and I think it would improve outcomes, and I think it ultimately could be the monetary saver despite the human cost, was it like a governor-led issue? Was it an individual in a legislature? Was it a secretary? Can you just give us an example on how another state tackled such a large scale?
I could give three kind of brief examples that are very different. Probably the first one was in my home state of Washington. The legislature commissioned a study in a tri-county area that was in the central part of the state, and just said what we're going to do is reduce caseloads, do salaries, and then expect standards, and we're going to see what that does over, and they studied it over 2 years. And what they found was more reunifications, faster reunifications, children in other permanency faster, fewer days in care, fewer continuances, because prepared attorneys were ready to go forward, and that they were able to cost out and find that saved money. And so in Washington, then the legislature just, over about 15 years, walked that program out through 39 counties. Contrasting that in Colorado, they had a commission led by a former Supreme Court justice who did kind of studies and everything and came to the legislature one year and said, this is what we should do. And they said, in July, we start statewide. And I was a little part of that implementation process, and that's a very hurried schedule. Oklahoma and New Mexico and Montana are all three very much more recent programs, and they were part of, I would say, kind of a middle ground there. They didn't take the 15 years that Washington took, but they did study it, work it out, work the budgets, pilot, and then kind of build out from there. The advantage of these latter states is they're happening under the new 4E reimbursement thing, so there is that extra resource of money to do that. The Colorado and Washington, for instance, were prior to that.
Thank you for that. Sounds like a wide array. And when you said you finished your prepared comments, I was looking forward for your unprepared comments. So thank you for that.
Representative Humphreys?
So just out of information, you know, we had asked the Judicial Council to look into the GL situation, and so they now have an advisory committee specifically to look into our guardian ad litem laws. And I do think one of the things they're looking at is that central control and how that might look in Kansas. And I mean, of course, they don't make the decision. They would recommend to the legislature, but there might be a recommendation coming. I think the committee is just now starting to meet, just FYI.
I was actually curious about that timeline, so thank you for that update. Any other questions? I have a few. So this preventative legal representation, that's kind of a new concept for me. When would that come into play? Like when they're being investigated, or?
There's a wide, sorry.
Thank you, go ahead.
I mean to cut off the question. There's a wide variety of ways that looks. There are two big kind of broad models. One, which is associated kind of closely with the agency. The agency is the large referral source. So the agency is saying, we're working with this family. We've been involved in an investigation or whatever. We're working with this family. And we notice that they have these, what I refer to, these ancillary legal issues. If somebody could get their Social Security benefits squared away, the kids could go live with grandma or something like that. Family law orders getting squared away, evictions being addressed, things like that. The other kind of broad-based model, and I'm drawing a brighter line than there is, but the other broad-based model is generally community referrals, individual referrals, where the family just is getting independent legal relationship, legal advocacy in that space, to do any of those things I just mentioned, but also working with the agency, trying to work out, making a plan for safety for this family so they don't go into care. The bulk of that, as you might imagine, is pretty in what we call the tertiary space, meaning we're not way upstream. We're in that space where some sort of call or concern has happened. There's work going on, and the agency and the family and everybody, we're trying to figure out what we're going to do in this space. That's probably the bulk of what is going on now. There are some programs that connect through community resources more upstream. The further upstream, of course, obviously the further away from a very direct connection to child protection that you get. So for instance, is a court that does just eviction relief, or a practice that does just eviction relief, a preventative legal advocacy and child protection? Just being evicted from your home doesn't mean your child is going to go into child protection, but there's some number of those who might, right? But so you're a little bit further away to call this child protection preventive legal advocacy, even though it might have that as part of its outcome.
Thank you. And then we heard a bill moving permanency from 12 months to 9 months. And then we also discussed maybe having different permanency options based on age of the child. So 0 to 3 would have a shorter permanency than a teenager. Do you have any national insight on that, or could you share any information with us on that?
I was just texting my colleague that we need to do some research. I don't personally know that we've done research on timing of the permanency hearing itself. What I do believe is kind of unquestionably true is the quality of the permanency hearing is based on the work that comes before it. When we talk about where cases end up, when we talk about how do we deal with long stayers, I know that's a common conversation, my mind goes to the front of the case. My mind goes to how did the first hearing go? How was the family, what was their walk through the front door like? What was the first 3 months like? Because so much is dropped and lost in that time period that what you get when we hear about these permanency hearings are cases that they've had 2 or 3 permanency hearings, right? Because they're 2 or 3 years old. What so often is the case is that we've dropped and lost so much at the beginning. And so we have families that are reluctant to engage and not really engaging, but not going away either. So, social workers or and attorneys and you get to a permanency hearing, it's like, well, there's some stuff being done, but not much, but we'd like to, and there's just indecision. And so it's, well, we'll continue on. And so whether that hearing is at 9 months or 12 months, to me, it's how do we get there? And so I would encourage, I wish I had a better answer about the specific question about the 9 to
That
12
helps,
months.
thank you. Representative Roser, you had a follow-up question?
Yes, thank you, thank you, Madam Chair, and thank you so much for stating that. I completely agree with you, and I think you hit that right on the nail, which was my questions from earlier. You know, that's why I was sorry if you felt like I was peppering you. I didn't mean to do that. That being said, you know, for dispositions versus permanency, because disposition hearings are meant to, they're intended to set the initial long-term care, which is that front load, how we can bring the best that we can for that child to that permanency hearing. And I don't know that I agree that a time limit's going to make that happen. But would you agree professionally that maybe instead of moving the permanency hearing up 3 months, that moving that disposition up or the disposition requirements to set that long-term care plan would be more appropriate?
The actual disposition, like that case plan, I mean, the idea of everybody getting together and saying, this is what's going on, this is what's needed, and this is what we can do about that, the earlier that happens, the better. Sometimes that happens in the first week. That's exceedingly quick. Agencies will generally talk about a month to 2 months to be able to really get to know a family in the sense of not safety, but case plan services. So again, I kind of would go to the idea of it's the quality of that disposition hearing is the primary. Putting it out 6 months and stuff would be time-wise a problem. The quality of that, because I'll go kind of one step further. When you write a disposition order for a family in a case, you're really writing the law for that family. Because the law, every kind of time the court comes to that family from then on, they're going to say compliance and progress with the case plan. That's kind of out of the statutes and stuff. And the case plan is what was written. So writing a case plan for a family is like writing the law that will apply for this family. Yes, the earlier you can get a quality case plan and engagement in it, the better.
Representative Carr?
Thank you, Madam Chair. And you'll kind of have to stay with me on this one, Rob, because I kind of lost myself as I was thinking this through. What I hear is that we could use more information to be certain that we've got a more clear picture. Now, I'm not aware of how often those case managers provide reports, for instance, to the court. But with respect to whether or not the family is following the plan, what the progress is, if they're following the plan at all, if too much time has taken place between the first time we said that they needed to take, course A, and now we're telling them again to take course A, and we've got 12 months at this point before anything comes together. In your opinion, would it be an advantage if we then shorten the time, and I don't even know what that time is, right? But and I'll just say that if there's a report that's provided to the court by the case manager that would take place twice a year, right? So they get 2 of those. Do you think it would be more effective if we, for instance, doubled that number? Then we would have a better picture of exactly where we are before we got to wherever we were at the year, at 6 months, at 9 months, whatever it was. Just your opinion on that.
What you're asking, Representative Carr, thank you for the question, is more frequent engagement with the court, more kind of repetitive oversight or shorter term oversight. And yes, I think that can be helpful. And in part because this is volume practice, just speaking clearly. Every social worker, every lawyer, every judge doing this work has a lot of cases. And one of the things that brings their mind to the case is a court hearing. Now, I want to caution that answer with the idea of thinking practice versus structure. When we go to look to attorneys or social workers or judges and say, this is the practice we want. Here's high quality version of your professional practice. That's, that's what we want. We have to understand, does the structure allow for that? So I spent the morning in Shawnee County Court watching court with Judge Moylan. She had a fairly light day this morning with 20-some hearings, just 8:30 to 12. Generally, she has 30 to 40 hearings on a half-day calendar. They took no break in the morning. So it was 8:30 to 12, no breaks, and that was a light day. I was exhausted watching, let alone the emotional kind of weight of that. When we say we should have more frequent hearings, that is sort of a, I don't know if best practice is the right way of saying, but that is a way to encourage cases to move along, bring people's attention to the case. You don't wait 6 to 12 months to find out a service wasn't referred or wasn't engaged. But the problem is we have to keep in mind, if we're making that now 60 to 80 cases on a half-day calendar, we're getting into a place where those hearings don't have any meaning and nobody can practically do the work that they should do there. So we have to be mindful of the practice we want to ask of our courts and then the structure that we build to allow that practice to happen.
Thank you for that answer. I think what I'm leaning more towards is, and maybe I'm speaking out of turn, but it would be my assumption that without there being an actual court date, someone has to be documenting, right, the progress along the way. And what I'm saying is that just that documentation piece, right, can we make that more frequent? And certainly it's going to be a heavier workload on those caseworkers, case managers, but it certainly doesn't increase the workload that is on our judges and our judicial system. And when they do get around to actually having that court hearing, well, you've got a lot more data, right? You can see what's happening. There's a lot less work to be done in the actual court hearing because you've got a bigger picture. You've got a better picture painted in front of you. And that's my thinking. And I was just curious to see how you felt about it. And I heard your answer and I appreciate it very much. Thank you.
Any further questions? I have one last question that I'm curious about. And you mentioned visitation or parenting time. And you kind of alluded to this, and I just want to make sure I understood this. You said kind of the faster we get that started, the better it is for the children. But sometimes it's delayed because the parents aren't, I took it as quote, ready for that, or they have to go through. Could you just kind of elaborate on that just a little bit?
Sure, and I'll be clear that I'm speaking nationally. I haven't studied the reality on the ground in Kansas. There are some states, I was doing a presentation in Colorado, for instance, and there were judges who were setting up fairly arduous and not, frankly, child, let alone family-oriented barriers that should happen before visitation should happen. Some of the classic thing that I would hope around the country we're not doing, but I suspect sometimes, is if a parent misses a therapeutic class, drug treatment or something like that, kind of as punishment, we're not going to do the next visit, things like that. So there are sometimes barriers put up for that. Sometimes the court will suggest we're not going to start visitation until, right, like documented sobriety or engagement in treatment or something. I want to differentiate between being sober in a visit behind the idea that we need to get to documented sobriety over time before we start visitation between a parent and family. So there's some of that. There's some resources. A colleague that was working in Mississippi, they don't start visits for like the first month or more, and it was largely, at least a perceived, again, I don't know on the ground too much, but of resources. And she was trying to recruit churches to host visits so that they could do visits more often. So there are some intentional delays, there's some resource delays, there's some just lack of understanding the value of supporting and lifting up the parent-child relationship rather than just, we'll do the minimum we can because it's their right to be together.
Like that sometimes defaults to just once a week. week, and that's just what we
Ooh.
do, click the box.
If I thought that was the worst version of that answer. The idea of a default is absolutely true. You asked, one of the questions was, what do schedules look like? And they should be different. I think it was Representative Roser. They should be different in every case, and almost every jurisdiction has a, well, your kid just went into court. Okay, it'll be once a week for 1 hour because that's what we do, or once every other week or something like that.
Should be individualized.
It absolutely should be.
Thank you. Thank you for that clarification. Any other questions? Thank you so much for being here. Great conversation. I'm excited about where we're going. We will be hearing the bill, let me pull that up, on Wednesday, that we're talking about the definition of neglect, which is HB 2132. So that bill hearing will be on Wednesday, so be prepared for that. On Friday, we will be meeting at 1:30, normal time, normal place. Sorry to do that, but we are going to be hearing HB 2175, which is the Miranda-style rights for Kansas. So if you have any questions before that, let me know about the schedule. And any last comments? We are adjourned.